Judge, I forgot to approach you on this other case. It's Miss Loyola. Judge, she has an AFM in our court, but she has a felony.
So she's on bond for an assault of a family member,
Yes.
on bond for a felony assault of a peace officer, and now you pick up a new case.
And what happened was she went to felony.
Oh, hold on. I don't even think we've done probable cause yet. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with possession of marijuana. You're facing up to 6 months in jail and or $2,000 fine.
Thank you, Your Honor. On March 19th, 2025, a law enforcement officer observed a white Chevrolet Silverado ahead of him on the block 12600 block of Wilcott Parkway and ran the license plate through the NCIC TCIC. Registration was shown to be expired as June 2024. A traffic stop was initiated and the law enforcement officer made contact with the defendant, the driver. The law enforcement officer observed a strong odor of marijuana, and the defendant claimed at first she didn't have anything in the motor vehicle, then confessed she had marijuana and several pipes. The defendant was detained. Probable cause search of the motor vehicle was done, and the law enforcement officer located multiple marijuana pipes. The law enforcement officer located a small bag of a leafy green substance and a black bag in the back seat. It was identified as marijuana, and the bag was within arm's reach of the defendant. Total weight of the marijuana was 0.09 ounces.
Since she has a license.
Yes, Your Honor. It does show being
Eligible or
ineligible.
ineligible? Not allowed to drive. You will now be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what your excuses are. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and or a $500 fine every time you drive. You are on bond for 2 cases. Your first bond violation report was filed in February for you not showing up for testing and not picked up a new case. I now revoke your bond on the assault case.
Judge, if I may,
Please.
she went to felony court, and she was also revoked there. She just spent probably 4 or 5 days there. Is that
Yeah.
right? And she's out here, so.
The day that means was I was in jail for a traffic ticket and a
The-
big call.
I don't know if you heard that, Judge, but the day that she missed court here the first time.
No one ever missed the
You missed
test.
it, that's right. She actually had texted me and she got taken into custody because of a traffic ticket. I have all that. So she was actually on her way to the testing and got picked over, and therefore she couldn't continue to make it there. So she's already been punished for bond revocation on the felony court, which she spent 5 days in jail last week. When did you get out on that?
Saturday.
Saturdays. And so if we take her in, I know you have a right to, Judge. It seems to me like it's kind of like a double whammy for her, especially for the fact that for that first BVR, she did honestly try to make an attempt to get there. I have the phone records for that, Judge.
When someone tells me something and they repeatedly fail to recognize the conditions that we set forth, for me, it goes in one ear and it goes out the other ear. You telling me something when you get out the doors, you still do whatever the hell you want to do without regard to bond conditions in this court. I'm now revoking your bond. She goes with you. Well, hold on. I need to sign this affidavit so she's not going to drive. And then she goes with you. I'm sorry,
Can
John,
I-
but it's just one thing after the other. Just
Do you want to go ahead and just issue a new bond, or can I revisit you in about an hour to figure out what we want to do, Judge?
Sure.
You want to do it that way? Okay.
Keep it down, we got a plea?
She went to court 16.
She did, oh, but we have to wait till you give me.
Well, hold on a second. You really want to do a probation with Mr. Proctor?
That's what he said, Judge.
You couldn't even stay out of trouble while you're on bond. Why do you actually think that you can make a probation?
Oh, you got someone
Uh-huh. Yeah, I've heard that before. How many times have I heard that before? How many bond violations have we had, Mr. Proctor? You know, you can lie to me, but you can't lie to yourself. You know, if you think you repeatedly fail to appear for court. You repeatedly fail to comply with bond conditions. How on earth do you think that you're going to be able to make probation where you have to do classes, you have to remain clean, you have to report once a month? You can't even report to court once a month. How are you going to do this for 12 months? History says otherwise, Mr. Proctor. Can we do a TRAS? Before I do anything, I don't know how to go forward with him. And I think that probably the best way to see is to have Mr. Proctor evaluated to see what conditions and what is the appropriate way to go forward, because I have no idea what's going on in your life. I have no idea what you have, and we don't want to see you fail, Mr. Proctor. We want you to leave better than you came. But just doing this right here, it's just throwing you out there to the wolves. I mean, if you really think that this is the appropriate way, you can even, while you're on bond for a couple months, stay out. Before, I would like to have him evaluated. So what we do is we have clinicians available that can interview you, talk to you about you, what's going on with your life, what has been happening with you, how everything has transpired and how we've gotten here to this point, and to see what's the best way that we go forward. Do we need a treatment plan? Do we need inpatient treatment? Is it sufficient to do out? I don't know, but I'm not ready to do this just yet. I think that we need to have the TRAS to see how we go forward. Let's see what they say, and then at that point, you want to court reporter regardless, right?
Oh, no, sir, no, sir. We will respectfully honor the
So let's.
request by the court.
It doesn't have to take long. I can expedite it so we can have everything done within the next couple of days. We're not talking weeks. We're not talking, so we can have everything done quick. Because I don't want you to just sit there and languish. But I need to know how to go forward. And this, I don't think that this is the appropriate way. If they say after we have you evaluated, if they say and they give the blessing, then I'm all for it. I want to do what they advise because they know best. Every time I have someone TRAS and I deviate from it, we pay dearly. So that's why I trust them to give us the best advice as how to go forward. All right? Give me a couple days. Let me get the TRAS done. We can come back and then we'll go forward. Okay?
Thank you, Judge.
Thank you.
I just want to make sure I had the rest of my day, so we just want to wait for the TRAS before we do the play.
Right. Yeah, because I want to know what are the appropriate conditions that we put? Because this right now, this is the type of probation that we usually do when people have, no violations or, they've been, but here we have multiple, 4 different violations from one thing or the other. So that's why.
Thank you,
Thanks.
Judge.
Okay.
Yes, sir. Thank you.
Hey, Your Honor, I'm approaching on Mr. Portillo Sanchez.
Judge, was presumptively positive for alcohol, fentanyl, and cocaine.
Your Honor, he wants to take a plea for 180 days today, which he's got 22 days credit, so.
I don't know.
All right.
I think the last time we had said a year, right?
Yeah.
We set it for trial, I think, on the 22nd-ish, and he wants to plead to 180. No, okay. Will you accept, is there anything the court would accept? No.
I'm over and over and over. And I don't know if that's what it is that's causing everything in all these cases. But I have a sneaky suspicion that it could be due to all that. You now tested positive for cocaine, fentanyl, what else?
An alcohol, Judge.
Alcohol. You were on bond for 5 different violent cases. Goes with you. I'm sorry, Mr. Portillo. What I would like to do, because obviously now we now know that there may be a more substantive issue that may be causing all this. So what I'd like to do is have him TRAS to see how we go forward. But I'm not going to just continue to take these cases where we're basically pleading guilty, throwing him in there 30 days, gets out, and he picks up another felony. We have now 4 or 5 open felonies. No, I'm not going to continue to perpetuate this revolving door of you picking up a case, getting out, picking up a case, getting out, picking up a case, and now you're testing positive. No, we will now get to the root of what the problem is and why you have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, now 15. It ends today. Goes with you? And we'll have him TRAS. Let's see what it says. And then, but I'm not just going to continue to do the same thing in hopes that when he gets out. So, send it for TRAS. We'll come back in a couple of days, get the report, and let's see what they say on how it goes. Okay. But I'm not going to just continue to do the same thing and hope for a unicorn because it's just not going to happen.
I would like to just,
It's up to you.
I would like, I mean, if,
Can,
but, right,
let's figure out what's going on.
sure. I just want to see what I mean,
Sure.
obviously as his attorney, I need
Absolutely.
to see what his options are and meet with
And I don't
him.
want you to do anything you are not kosher or not happy with, Before we do anything, of course I want your blessing. And if he says no to what they say, then we just go
Have
to
a
trial.
trial.
And we'll go one after the other. Just be ready, please. Okay.
Should we, I guess, set him like for Friday or something and see, I don't know.
It's probably gonna be the process today. I don't know if we're tomorrow.
There's no way. It's now 11:30. Till tomorrow, he's still gonna be processing.
Right.
So we can't start the TRAS until he's out. Latest will probably be Wednesday is when we get it done. I would say we probably will have the report.
Well, but he'll be set for bail review automatically, right? For Wednesday or?
But if he stays in holdover, somebody can come over there.
We usually have people come here to do the TRAS here.
Right,
while
okay,
they're Here, to
okay.
try to expedite it so that they don't sit there for a week or
Sure.
2 weeks, because we want to, it's not the idea, it's just to hold, just for the sake of holding, is to get it done quick so you guys can make the informed decision quick. And we'll see, and the idea is hopefully he's honest and then try to get to the cause because,
The options.
before there's a murder case because he's using and he does something that's irreparable,
I
I
understand.
mean, how many times have we seen it? So, okay.
Thank you.
Tiger.
Sorry, Judge, I just have,
Man,
I'm terrible. I am in this death penalty capital, so I just don't.
still?
Yes, Your Honor, we're 2 out of 3 weeks. I just have 4 minutes left on my bathroom break. Mr. Thomas tested, it looks like his marijuana levels are going down, but he did test positive for alcohol. I talked,
Mr. Thomas.
he's present, Judge.
Not only have I reinstated his bond once already, but now we're working a second bond violation warrant. What do I need to do to get your attention, Mr. Thomas? Yeah, right. Justin,
Yes, Your
what
Honor.
do I need to do? Put his butt in jail?
I think we've been in felony court this morning, so I don't want you to think he wasn't here. He was,
I don't
he
care
was,
about that.
um,
I care about him continuing to use and continuing to do whatever the hell he wants to do without regard to bond conditions. You do what you want to do. I think I have but one choice, Justin, and to just put him in jail.
Judge, what do you think about some AA meetings or some?
I don't think it'll. When did we order him not to use?
What was the last name again, Judge?
This is Thomas, Mr. Thomas.
Positions were set in place on October 11th.
This past October, we told him not to use.
The marijuana is negligible, so it's almost out of the system. It was a 0.005, I think. I understand the court's frustration and concern.
If it's been bond conditions since October, we're now nearly April 1st. It's been 6 months. So it should have been way, way gone.
No, it was from the positive. So you admonished him on the positive not to use, and then, so this was his first test since,
February 6th.
right, and so that's what I'm saying. So the marijuana is negligible. I know it's not an excuse, but I don't know that we read all of our bond conditions about alcohol. Now, I know that's not an excuse because he signed for it. I get it. But I do want to point out to the court that the marijuana is basically out of the system. It was like, that's why I'd asked for the levels, but it was like at a 0.05 or 0.005. It was,
Should we see that?
The levels, Judge, let me see if it's in the email.
it was, I asked for them, Judge.
I know. I saw that you did. What do you do for a living? Where do you work?
So it's pizzeria. I'm a chef.
What is it?
So it's pizzeria. I'm a chef.
He's a chef at Russo's Pizzeria, and we're in school. So we are being productive members of society.
How do I know that? Am I supposed to take your word for it?
You can take his mom's, Judge. I talk to his mom pretty much on a regular basis.
Judge, if you see that number, however, truthfully, I don't know what that means. But it is a low number. So that's all I have to offer for, but.
Here's what we're going to do, is I'm putting a scram monitor on his ankle, so I know that he's not consuming alcohol.
Yes, sir.
I'm now going to put a GPS monitor and I'm giving you a curfew, because I don't want you out in the middle of the night. I'm giving you a 10 p.m. curfew. If you ever have another bond violation, I'm going to revoke your bond and I'm going to make it so high. Do you understand?
Sure.
I'm sorry.
I will test you again in 2 weeks. If you test positive for marijuana after 2 weeks, then that tells me that you've continued to use, and I'm going to lock you up. Do you understand?
Sure.
Thank you, Judge. Maybe excuse to go back to very important cases.
Yeah, so he's back in 2 weeks to test. If he tests positive after the 0.05 nanograms or whatever the hell it is, if he's still testing positive.
I have
then
nothing.
that's
I have
it.
nothing left to say, Judge.
All right.
I will be speechless.
All right.
Your Honor, I am here on Mr. John C. Joseph, BBR, alleged BBR violation, Judge. Sitting over in the jury box. It's my understanding that he left his area curfew area on 9:07 p.m. on 5/20 came back at 9:31, approximately 24 minutes. I spoke with him. It's my understanding that he went over to his sister's house because he and his girlfriend had gotten into a heated discussion. He informed me.
Mr. Joseph.
He informed me that he left to stop proceeding the assault, possibly assault between the two.
I do everything in my power to try to prevent people from going back into custody. But some people just refuse to just, I don't know what I can do to get your attention. You now have 2 open cases, and now this is your second bond violation. What do I need to do to get your, what do I need to do to get your attention? Is it putting you back in jail, Mr. Joseph, and making your bond high? Your actions tell me different. This is what we're going to do. I'm sending him now for a drug and alcohol test. I want to know what, if anything, is in the system. You were to come back. If you fail to test, if you fail to take the test, if you fail to come back, it's not going to go well for you. Do you understand? I don't want you to say anything. I want you to go take.
I'm offended. I'm having time for Luis to get on my system.
You have been on bond, Mr. Joseph.
I think the last time he was in court, Judge, I think he made an admission that he had used drugs during that court appearance. And if that's the case, he may be correct in that it may still be in his system, Your Honor, because it hasn't been 30 days.
The first burglary of a motor vehicle has been open since June of 2024. Since that time, I have told you not to use.
Okay.
Take a seat for me. I don't know what we're gonna do. Take a seat.
Thank you, Judge.
You were here in June last year. Because you came in late then. Now we have another set of bond violation for you coming in late. Why would I continue to let you go? I let you go already once and you did it again.
Instead of voting on Thursday.
Do you see what I mean? Because me, if I let you go, then I'm telling you it's okay for you to do what you're doing, when it's not.
Judge, if I may, I believe that he has a legitimate reason. I believe that if he had not gone, there was the possibility that an assault or some other harm could have happened to his girlfriend. From my conversation with Mr. Joseph, he informed me that he left, and it was just for only 24 minutes. He left in order for both of those parties to cool down before a fight or an act of violence escalated between those two parties. I personally think that that was the right thing to do.
Who do you live with at home?
My girlfriend, but my sister stay right down the sidewalk in the same apartments.
Same complex.
Yes, sir.
She doesn't live with you.
Huh?
She doesn't live with you.
No, not my sister.
So who is the fight with?
It's my understanding that it was his girlfriend.
Is it the family here?
My girlfriend here.
So the fight was with who?
It wasn't a fight, it was a words that was about to escalate into a fight, at which time he left for a cooling off period with his
My
girlfriend. And he left, nothing serious could have happened. I believe that was, even though it was a violation of the bond condition, I believe that it could have been worse had he not left.
If you put your hands on anyone, I don't care who it is, if it's a woman, if it's a man, I'm gonna put my hands all over you. You don't understand.
Yes, sir.
Nothing in this life can justify you putting your hands on anyone. You have
Man, my
two.
hands on her. I just left so the situation can cool down.
You have two open cases. At all times, you need to be thinking to yourself, if I do this, what's going to happen? If I say this, what's going to happen? If you're going to antagonize, meaning if you're going to say something that makes someone flip out on you and the laws come over and they see you and they look you up, 9 times out of 10, they're going to go against you. You need to be thinking of these things at all times. You get into a fight with them, words, it's always going to end up bad for you. I understand and I appreciate de-escalating the situation, meaning you're leaving so that it doesn't end up in anything more. But it shouldn't be like that in the first place. Are you working?
I just did 3 job applications. I'm waiting on the interview to come in.
Judge, yes, sir, I know you are.
I don't care.
I do, Judge.
Why aren't you working?
I just recently started looking for jobs.
You have too much time on your hands. You need something to do in this life before it takes you down. When you have too much time on your hands, you become self-destructive. You need something to do in this life. It's time for you to start working. And I want to see that you get a job. Toria, can we help him out?
Yes, I'll give them some resources.
We're going to give you resources to try to help you get a job. There's no reason why you can't have a job within the next couple weeks if you try. When you put your heart and soul into it, you can achieve damn near anything. It's just how badly do you want it? That's what it amounts to. And when you do get a job, if you really do a bang up job, and if you do well and you don't do stuff half-assed, all you're going to do is you're going to go up and you will make more money. The higher you go up in a job, the more money you're going to make. And then everybody's happy. When you get to buy nice things, that's what life's about. Not the janky, stupid ass jobs where you're making $6 an hour. No. Work hard so you can make a lot of money. All right.
It's great.
I'm not going to ding you. I don't want any more issues. Do you understand, Mr. Joseph?
Yes, sir.
I'm bringing you back in 2 weeks, and I want to see that you have a job. 2 to 3 weeks. If I see that you haven't put any effort into it, it's not going to go well between us. I also don't want you to use any dope. Do you understand?
Yes, sir.
If I find that you're testing positive, likewise, it won't go well for you. All right, Mr. D.
Thank you, Your
You're
Honor.
good.
Just approaching on a new fugitive case, it's Robert Mizell. And Judge, he would like to have a bond set. It's kind of an odd one, Judge. It's failure to possess the required license for home improvement or residential construction. And basically, Judge, he told me that he owned a construction company, but he's totally blindsided by this charge.
Good morning, Mr. Mazzell.
Good morning.
Your lawyer's asking for me to set you a bond. You
Yes, sir.
now stand charged with, I guess you said home improvement fraud.
Judge, essentially, that's what it sounds like the allegation is. It's a failure to possess the required license for home improvement.
I have your fraud.
This was in 2020 during the 3 hurricanes that hit Louisiana. And according to City Hall, and we went down to everybody and they said we didn't need one because it was an emergency situation. Everything was flooded and devastated and we were just trying to help out.
My only issue is that this is now a second fugitive case that you have.
The first one was a lady that we did work for.
Let's be careful.
Doesn't matter.
Oh, sorry.
This, Mr. Mazzell, is that, we usually, as a matter of courtesy, I guess, so to speak, we'll give you a chance when you get one fugitive case. But we can't continue to do the same thing over and over and over.
Understood.
Amy, what do you know anything about this?
Yes, so first off, state as opposed to a bond. This particular case is because he didn't have a license, but it originated out of the fact that the complaining witness after a hurricane had paid the defendant money to repair her house. He did not do so. The money amount was.
So he allegedly took money for fixing the house and didn't do the work.
Correct. And then when the officers went to go look him up, he didn't have a license under that name. So that's the basis the basis for that charge. We are, of course, opposed to a bond given that he has had a prior fugitive case. He was granted a bond on that one, but he didn't actually show up. Looking back at our notes. The only
So
reason.
we gave him a bond, he bonded out and he didn't show up?
No, he appeared,
No.
yes, he appeared in court on that day when you guys provided him a bond. He appeared in our court here in Harris County.
Okay.
The only reason that case was dismissed is because I believe that the main jurisdiction in that case had recalled their warrant or something of that nature.
So he didn't turn himself in.
No,
The lady that was charging us, I ended up paying her $21,000. And she dropped the case.
How? Am I supposed to, we can't just take everybody's word for
Well,
what they
but
say.
first off, I did not know that even the warrant existed. So I had no idea. But I ended up paying the lady off. I gave her some money and said, okay, that's good, we're fine. I truly didn't think we did a very good job.
Okay.
But may I ask you this? This is an LLC. I have a business, or had a business partner at the time. We were 50-50 in the business. I just wonder why I'm the only one being charged here. I mean,
Facts beyond what I would know anyways. The simple thing about it is that I gave you a bond last time. You bonded out.
Yeah.
You didn't show up. And now you have another fugitive case. We can't
I
continue.
bonded
we
out
can't
and I
continue.
paid the lady off and she dropped the charges.
That case was dismissed? Is that
Yeah, the
correct?
case was dismissed.
Not because he showed up like he was supposed to.
I see what you're saying,
He
Judge.
came to court on the day that he was due to go turn himself in Louisiana. I don't know, but I can't continue to do the same thing. The good news for you, Mr. Mazel, is that it's Louisiana. So we have buses coming from Louisiana probably 2 times a week. So from the time that you waive, within the next probably 2 to 3 days, you'll be back in Louisiana to be able to answer the charge. But I'm not going to just continue to give bonds on fugitive cases when you continue to pick them up. Because
Got it?
okay. Has he waived or did he refuse?
To refuse extradition.
Okay, so you need to decide what you would like to do. If you want to waive extradition, I would say probably within the next, 3 days, Louisiana will be here to come get you. If you want to refuse, which is well within your right, the state can get a governor's warrant, but that'll take 90 days. And at that time, they can have you remanded
I
back.
could sit in jail for 90 days. No, I'm not interested in that.
So, but I'll let you talk to James to figure out what you guys want to do, and then you just let me know.
Okay.
Mr. D.
Yes, sir, Your Honor.
So much here for like another.
Your Honor, I'm trying to find out where are we with Sean Sullivan?
Sorry.
Yes, okay, Judge. Sean Sullivan, Judge, is my
You
understanding.
got it. Okay.
Yes, I have the case. I wanted to know, were you concerned with DVD? Did you want to get any DVD involvement?
Michelle?
Yes, is this the NBC one?
Yeah, this is the one that we were talking about.
We'll let it stand. They just want to stay there. So they don't have anything else to add.
Okay.
So I had a concern because is it mutual combat? Because
It looks like from my understanding, Judge, looks like the complaining witness is the person who actually initiated the contact. She was alleged to have been lying on the couch or not dressed appropriate in the presence of 2 other male men that resided in the residence with them. And he tried to wake her up to let her know that she was dressed inappropriately. And out of slumber and sleep, she woke up angry and started hitting him, and that's when the altercation.
she pops him 3 times in the mouth initially,
Yes, Your Honor.
and then they fight.
And the
But
police,
there's no assault from him at that time, right? I guess they separate, they part ways. An argument ensues later. Does she go at him and that's when he hits her?
That's not what we
So
have.
tell me that one part. What happens then?
Yes, Your Honor. So it seems as though the complaining witness, she crawled into bed and was laying on the corner of the bed when, after about 10 minutes go by, then the defendant comes back and begins to argue with her, crawls onto the bed, grabs her, flips her backwards on the mattress, and uses body weight to lay on top of her while placing both of his hands on her upper arms to hold her down.
So there's no,
And there is a subsequent punch where the defendant uses his right hand and punches the complaining witness in her mouth, causing pain and visible injury.
it's my understanding, Your Honor, that this incident occurred on a date certain, at which time the complaining witness told the police officer that she did not want to press charges and he did not want to press
right,
charges.
but
And they came back the next day.
why is it that they didn't file assault charges on her on the first? I mean, are we going here just because she's a woman? She gets a slide for getting to hit him? You know?
Was there, I don't know why this is.
I know there was no arrest on the initial date the incident is supposed to have occurred. The arrest occurred the following day. The first date, the officers did not arrest either party, but some type of disturbance occurred the next day. Officers were called, they came in and they looked at the report and they arrested the defendant.
My guess is, when I limited knowledge of intake, they probably put a call in the intake, they said, yeah, I don't know, it's just my guess. Refer out, do follow up, and then they went back out there next day, saw the referral on file, and they decided again.
So he goes up to her and he sits on her. Is that what you're saying? What happens? He turns her over.
More so, she's on her, from what I understand from the devs, she's on her stomach. He turns her over to where she's on her back, and then he is on top of her and holds
He's
her.
straddling her like this.
Yes, Your Honor. And then subsequently after that, they were still arguing and he punched the complaining witness in the mouth.
I don't see where that's, if she was the initiator of the confrontation between the two parties. It's my understanding, it's my understanding, from the complaint, from the defendant's perspective, it was not a hit with a fist. It was a push that caused various injuries to her mouth, but he did not take his fist and punch
Oh,
her.
but that's, of course, what he's saying to you, right?
Right.
And then you're saying that there was a hit to the mouth.
And she didn't press charges. She requested that no charges be filed. Somebody got punched in the mouth. If that were the case, you would think that someone in their right mind would say, yeah, arrest that person. However, if that person realizes that he or she is possibly responsible for the incident, then that would probably lead them to say, okay, I started this message, shouldn't have started. I don't want to press charges.
10 minutes pass, right?
Allegedly.
And I don't know why they didn't. Come up, Mr. Sullivan. Let's do this. Let's set it for a formal probable cause hearing. Okay. I'd like to do some additional research as well before I find probable cause in this case. So what I'll do is I'll put this case on for Wednesday for a formal probable cause hearing. In the interim, Mr. Sullivan, I'm ordering you not to have any contact with this person whatsoever. You understand?
Yes, sir.
I don't care what's going on in your life.
I got you.
For the moment, I'm gonna, I don't want you to have any contact. I don't want you to go where this person lives, where this person works. If I find that you do, I will revoke your bond, put you in jail.
Yes, sir.
We'll come back in 2 days. I would like to do some further research on it because, I really like to look at every case, do a deep dive to ensure that there's probable cause before we go
Appreciate that,
forward.
thank
So, I don't blindly find PC for anyone.
Yeah.
I'd like to do things in the fair way, but at the same time, I want to ensure that my county and every person in it is protected. So don't have any contact with this person. We're going to create bond conditions to this effect. They're probably going to reach out to her between now and Wednesday. And if they find that you're trying to communicate with her, it's not going to go well. You understand?
Yes, sir.
You mind filing no contact in the weapons, please?
Yeah, sorry. No context, I'm sorry.
No weapons.
No weapons, Your Honor. Thank you.
And one of the things that they teach us is, never make rash decisions because it may be the wrong decision. And that's why I'd rather take a little bit of time before we do something to ensure that what we're doing is the right thing to do. So we'll put it on for Wednesday, come back Wednesday, and then we'll have a decision for you.
Thank you, Your Honor. Appreciate it.
I've given you a lawyer, so just stay in touch with Mr. D, and then we'll come back, and then we'll finalize it for you.
Thank you
okay?
so much.
Don't leave until you sign our bond conditions, okay?
Thank you, Judge. Appreciate it.
We appreciate that, some message files, they know what's going on.
Yeah, great. Maybe they can be here Wednesday if they add anything further, and then we can. Okay.
Thank you.
Judge, I am here on our friend. I feel like almost like he's family. Daniel Frazier.
Okay.
He was charged with another escape.
Oh,
Um,
we got him back.
yes, sir. Yes, sir. I was surprised to see him pull up on my docket as well, but not really.
Will you stay on it?
Yeah, I'm on, Judge. We have a decent relationship. Even though we believe we know how this is going to go, at least from you, because right now the bond is set at $50,006, and $50,000 in the felony court. He wants me to ask you for a time served. I believe I already know what the answer is going to be. And in the event that you deny my request for a time served, he said he's willing to go back into treatment and he's willing to complete treatment this time. Now, I don't know how that's going to affect him upstairs because
Ours until the upstairs is taken care of, because they won't take him with an open felony.
Understood.
Kind of
understood.
standstill until.
And the big problem is I'm not representing him upstairs. his court date is like May the whenever, it's like really far down the line. Yeah, so.
Get you going. Do you mind bringing up Mr. Fleischer, please? Thanks. How are you?
I'm good.
You're back.
Yes, sir.
Good to see you. How are things? Good. What's good to see you?
We're good.
Say it again.
So they were good.
You know, you can run, but the long arm gonna get you every single time. You can only go so far. Sorry, no time, sir. You know how it goes. I told you, every time we come back, we're gonna do it until it takes. And you
So
know,
my only option, in all honesty, my only option for this, for the misdemeanor is treatment. There's no other option. No matter what. No matter if I got treatment on my own.
really, really,
I mean, I've done it already. I've done it once. I've got behavioral treatment and I've also got mental health. Behavioral and also substance abuse treatment. I've done both already.
I want to use ours. The problem is that I cannot do anything until the case upstairs is taken care of. So we're kind of in a holding pattern until upstairs. Hopefully, they will see that that's what we want to do here, and they'll, you know, but I don't know. I can't. You're not representing upstairs, right?
No, sir.
So we got to wait to see what happens upstairs, and then we'll just. Told you we're just going to keep doing it until it takes. Hopefully, one day it does.
I really don't. I don't have a substance abuse problem. I really don't. And honest to God, I don't. Like I've stopped a long time ago. And honest to God, I've stopped, and I'm not trying to go that path. Honest to God, I don't have a substance abuse problem issue. I've stopped.
So I guess let's set it for 30, Mr. Brooker. We'll wait. Because if they take care of it beforehand, you know, we'll see. And then if it's still set for the May 17th, we'll set it for the day after at that point. And then we'll see. Hopefully, you know, reach out to the lawyer
I am, that's what I was
upstairs,
gonna
let
say.
them know this is what we want to do here. Hopefully they'll see that that's what we're trying to do. And then, you know.
So basically, I'm waiting for the felony to see what happens.
Hopefully they will see what we're trying to achieve and be on the same page as us. You know, this is the second time you're facing this charge upstairs. They may offer you 4 years, 5 years upstairs. You know, it's no joke. You know, I'm trying to help you, Mr. Fleischer, believe it or not. You know, really. You're facing a lot of time and it's not the first time. So if you try to, you know, we played this game the first time. I don't know if they're going to.
Yes, sir.
Anyway.
It's a different court, Judge, so I'm hoping that we can have a similar outcome. And if they do it beforehand, I'll come off
I
document.
want to do it. And hopefully if they see that you're really willing to. So, all right.
Yes, sir.
I just want to say hello. That's it.
Yes, sir. All right, thank you.
We'll see you in 30.
Yes, sir.
Judge, I'm approaching on a plea for Mr. Lacero Tremendia.
I'm ready when you are.
All right, I'll call him up, Judge.
You were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 9 days in jail. Days that you have done. You need to understand what's going on your record. Be there for the rest of your life. When you get into a car, you drive. After having consumed half of a beer, you get pulled over, an officer sees a product of your hand, smell anything in your car that you understand.
Sí, señor.
Yes, sir. Another DWI, and you do anything more than 6 hours in jail, you will probably get an immigration detainer if you're not in this country with permission. Consider these things when you're out there in the free world. You understand? From now on, it is a minimum of 90 days in jail for any new cases that you pick up. No more proverbial slaps on the wrist. You're giving up the right to a trial,
Tienen derecho
right to compel witnesses to testify on your behalf, confront and cross-examine your accused.
testigos a sus
If you're not a citizen or a possible immigration consequences, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record forever and a day. You understand?
¿Entiende?
This is what you want to do.
¿Esto es lo que usted desea hacer? Yes, sir.
How do you plead to the offense?
¿Puede
Guilty
declarar
or not?
culpable o no culpable? Guilty.
I'm going to find
Oiga,
you.
y es culpable, suspender su licencia por 90 días.
Do not drive
No maneje.
until you get a license and insurance in your name. Otherwise, you will be back here and it's not going to go well for you. Good luck.
Judge, the only thing is, I'm appointed on this case. I wanted to see if you'd consider waiving the Supermax fine for him.
What do you do for a living? Mr.
¿En qué
Chimendi?
trabaja usted?
Ahorita no estoy trabajando.
Right now, I'm not working. Su
Asking
abogado está pidiendo que
waive
yo no le
$4,500 to around $5,000
hasta $5,000
that would otherwise apply to you.
que serían
It
aplicables
is a first
a usted
DWI.
como esta
So I will.
primera
But if you come back with
si regresas con otro delito de conducción,
$6,000 surcharge,
son
we
$6,000
the second
de
DWIs. And if you don't pay it, you do 1 day in jail for every $100 you owe.
Si no lo pagas,
So you will find that you
$100
spend
cada día.
months in jail and you pick up another one, potentially. Do you understand? I'm not
Yes, sir.
asking for much. I want my streets safe. And if you're not going to comply, then I have a place for you. Good luck.
Thank you, Judge. Appreciate it.
Good
morning, sir.
Sir, you were in February charged with terroristic threat of a family or household member. It's come to my attention that you have now picked up a violation of a bond condition or a protective order. I have no idea what happened, but I want to find out. You have the right to remain silent. Anything you say can or will be used against you. I want you to know that you're not here alone. I have a lawyer for you here. He's right there, so you know that you're not here alone, okay? Okay, so what happened in the DPO, please?
Well,
Not you. That. You have the right to remain silent. Exercise that.
On March 29, 2025, law enforcement officers were on patrol when they observed a white Honda Accord driving south on a public city street located in Harris County. The law enforcement officer ran the vehicle's license plate through NTIC and observed that the vehicle's registration had been expired since June 2023. Law enforcement officers initiated a traffic stop and activated their emergency equipment and followed the defendant's vehicle that drove into a gas station parking lot and pulled over to stop. The law enforcement officer approached the defendant's vehicle and observed the passenger sitting in the front seat wearing a seatbelt. The defendant requested the full name and date of birth of the passenger, who identified herself as Stephanie Avalar, and that was confirmed by the law enforcement officers. The law enforcement officer also found that that her name came back as a protected person from a recent violence incident, and ran the identifying information of the driver, also known as the defendant, that came back under the same protective order as the defendant for that case as well. The law enforcement officers reapproached the vehicle and detained the defendant, and confirmed that one of the law conditions and the protective order was the defendant shall have no contact with the
So it's just the by virtue of the, so we had issued the no contact, right?
Yes, Judge.
All right, so Mr. Avilar, I'm going to find that there's sufficient probable cause to go forward. You have to understand that when we have court orders, we mean it. It's not hard. You have a lawyer. When you want something changed, you talk to the lawyer. The lawyer can come to us and we hear things out and we can change things. But when you try to do stuff on your own, everything goes sideways, and it goes sideways quick, as you now know. So,
In Your Honor, we will be, would like to approach off docket tomorrow to try to have the MOAP amended. The state did in fact try to call the CW, but they have not been able to speak with her to clarify that she would in fact like him to be able to come home and have contact and the like.
So what happened? Is he?
Terrorism threat. He appeared in peace court on February 13th. He received a PR bond, and
Right.
next week he came in here for arraignment. He appeared. He got a reset for April 23rd.
Right, but I'm showing now he's bond active after the new case. Why? Did they give him another PR bond?
No, this case was never.
Look, it shows bond made on the terroristic threat.
That's from the previous PR bond. He was never revoked after since the new case. This case has still been on bond.
Did they not address it? And I'm at a loss if they never addressed it.
It was new court. His only reset is for April 23rd.
You know, Mr. Woodward, my concern is that, they gave them a PR bond on the terroristic threat. I don't even show that a PR bond was given. Oh, here we go. On 2/13, now he's picked up a violation of protective order. So I can't continue to give you a PR bond when you're picking up new cases, man. You know?
Can I speak? Could I ask? It's because I made bond.
No.
Sorry.
You need to talk to your lawyer before you talk to me, because I don't want you to say something that hurts your case, you know?
Sure.
I'll give you time to talk to him, but I can't, we do things a certain way. You can't do stuff on your own. You've been through the system long enough to know that, you know?
Yes, sir.
Are you on parole at this time?
No, sir, I'm not on parole, but I paid for my bond.
Hold on. So no PR bond on the terroristic threat. Okay, let's do this. Your lawyer said he can be here tomorrow. So we'll have him come here tomorrow so he can talk to you and you guys can regroup, try to figure something out. So Mr. Woodward, you say you can be here tomorrow?
Absolutely.
You want to address it, I guess, then?
Yes.
Okay, so we'll roll you to tomorrow. We'll try to figure something out.
Judge, he's supposed to get released today because of surety bond on the BPO.
Rep, I'm not giving him another PR bond when he picked up a VPO though.
Do you want me to revoke
The PR bond, yeah.
No,
Your Honor.
Yeah.
I certainly understand how you work, but since I'm not there with my client, I just like for him to experience that. The facts of the underlying case, Your Honor, are that he and the CW they're in a relationship. They had an argument. She grabbed his hair first, was pulling him. Then he was grabbing her, but a text message was sent from an unknown number saying, "If you don't come home, I'm gonna fuck you up." Excuse my English, Your Honor, but that's what was the crux of the PC, Your Honor.
Of which one?
For the terroristic threat case.
I don't know. I guess what happened in the terroristic threat?
Yes, Your Honor, if I just have one moment.
My understanding is that the CW is willing to communicate, that there was a little bit of a misunderstanding of the facts. I believe the state called her once. She said she wasn't available, but she would be if they called back. I don't think that she's been able to communicate that there was a little bit of a misunderstanding of the facts.
Your Honor, what I have is that this was the threat was made during an altercation where the defendant told the complaining witness, and I quote here, I apologize for the language.
Don't be shy. Come on. We all know the F word.
I'm going to fuck you up if you don't come home.
I understand that made during an altercation, Your Honor.
Don't come home. It was made during, the defendant admitted that there was an altercation, admitted that he told the complaining witness, "I'm going to fuck you up if you don't come home."
Your Honor, I'm looking right at the summary of facts. It literally says, on her cell phone contacts, the complainant stated the defendant then began to threaten her via cell phone text, which he stated, I'm gonna go kick your door. I got you. I'm gonna fucking kill you. Complainant stated she was fearful for her safety. But before that line, it says they came from an unknown number. It says it in the summary.
Your Honor, it is further down in the summary of facts that there is an admission.
Of course, Mr. Woodward, someone can make something from an unknown number, but they can corroborate it at the same time, And I think that's what the state is saying here, that he corroborates the actual text message saying that I'm going to go fuck you up. right?
Yes, Your Honor.
Yes.
The problem is that we have him, he's still doing stuff on his own. You know, I've told him not to do it, admonished him not to do it, and he's still, you know,
Yes, sir.
in this life, when you do things the right way, good things happen. When you do stuff the way you want to do it in violation of orders, and you've been through this sufficient that you know. Now, it's not the end of the world, but how do I get your attention so that you realize that we mean business? If I just give you PR bond after PR bond after PR bond, I mean, we have no teeth.
Yes, sir. I paid out of my pocket to get bonded. They gave me a bond downstairs and I paid
When
for
you're
it.
on your VPO, but I'm not going to give you a PR bond when you're picking up a VPO.
She called me, her home had it.
I'm not gonna, no.
Alright.
Like I said, talk to your lawyer
Yeah.
first. Start telling us stuff, because I don't want you to put
Yes,
yourself
sir.
in your mouth when you think you're trying to help regardless. Now, look, we can come back tomorrow. He's gonna come here. We can try to work something out. But
I was just trying to help, sir. I've been staying away from her. I got like 10 days left.
Sir, I got you. I'll come check up on you, okay?
back tomorrow, we'll deal with it and we'll figure something out. So you'll definitely be here tomorrow, Mr. Woodward?
Absolutely, Your Honor.
Okay, so I'm gonna revoke it for now. Come back tomorrow, we'll talk. Do you have a place so they can reach out to the complaining witness so they can get a rip done by tomorrow, Mr. Woodward?
I do not have it readily available, Your Honor. I can likely get it.
Okay, so can you try to do a rip between now and tomorrow? So we can try to figure out what she wants and then we'll go forward, please. Okay, all right, we'll see you tomorrow.
Thank you, Your Honor.
All right, bud. Good morning, Ms. Stews. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On March 18th, 2025, at 5:21 p.m., an officer was dispatched to a theft at Walmart with a female in custody. Upon arrival, the officer took custody of the female identified by her Texas driver's license. The officer searched the defendant before passing custody over to another officer. That officer spoke to the loss prevention officer who stated he was following defendant in the store and observed her concealing items in her purse and backpack. This was done in a blind spot of the cameras, so there were not videos. The defendant then continued shopping before checking out and paying for some items. The defendant did not pay for the items she had concealed in the bags and passed all points of sale before the loss prevention officer stopped her. The defendant admitted to stealing before turning the items back over. The total value of the items was $120.86.
Thank you. Ms. Dews, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walmart for any reason whatsoever. If I find that you do, I will revoke your bonds, put you in jail, and no more PR bonds for you. Do you understand? Yes, sir. Likewise, if I find that you pick up any new cases, your bond will be revoked. You will go into custody, ma'am. Do you have the ability to hire a lawyer? Okay, I will have you fill out an application. Deputy Miranda is going to give you an application. I'm going to have you sign a receipt with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions ready. Do not leave until you sign them. Okay? Please. Do you mind filing those? No going to any Walmart? Anywhere.
No Walmarts anywhere?
Anywhere.
Thank you.
Frank Reyes.
Yes, sir.
Mr. Reyes, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Simply. Okay.
Officer was dispatched to a minor crash in Harris County, Texas, where the defendant had rear-ended the complaining witness. Upon contact, the officer found the defendant in the driver's seat, slipping in and out of consciousness. When the officer woke the defendant up, the defendant attempted to start his car and drive away, but at that point, officers had his keys. The officers did not notice any injuries on the defendant. When the defendant exited the car, he was unsteady, and officers observed an odor of alcoholic beverages, bloodshot eyes, and slurred speech. The defendant admitted to drinking at a bar earlier. Standardized foot sobriety tests were conducted, and the officers observed 6 out of 6 on the HGN, 8 out of 8 on the walk and turn, and 4 out of 4 on the one-leg stand. While en route to the Joint Processing Center, the defendant fell asleep in the officer's vehicle. At the Joint Processing Center, officer read the DIC and defendant consented. However, the defendant fell asleep again and began vomiting. The defendant was transported to the hospital and a blood warrant was signed and executed.
So no breath test was done.
No, Your Honor.
Mr. Can you run his license, please? See if he has a valid license.
Yes, Your Honor.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with your case. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not, I'm going to give you a portable device. You're not allowed to drive any vehicle from now on that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock on it, I'm going to put you in jail and I'm going to make your bond high. Do you understand?
I understand.
It says ineligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. Mr. Reyes, heed this warning. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand?
I understand.
You cannot justify driving for any reason. I don't care if there's a burning building and you have to save 50 babies. Do you understand? I'm sending notice now to DPS so that every single officer in the state knows that you are not allowed to drive a vehicle that doesn't have an interlock. If you're caught driving a vehicle, it doesn't have an interlock, they will arrest you and put you in jail. I am now giving you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You will also be tested for illegal drugs as well. You test positive, you consume alcohol, into jail you will go. You have the ability to hire lawyers, sir.
I do.
We're going to give you time. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria. We'll have you sign a reset. You will get with Felicia for your bond conditions, and after that, you're free to go.
Please, I'm so glad that you can.
Good morning, Mr. Sullivan. Sir, you were charged with assault with a family member. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On March 23rd, 2025, at approximately 15:39 hours, the law enforcement officer was dispatched to an address in Harris County, Texas. In reference to a disturbance, the law enforcement officer arrived on scene. They made contact with a witness who stated that her husband, the defendant, had been arguing because her adult daughter does not like the defendant and asked the complaining witness to pick between having a relationship with her and her grandchildren or the defendant. The complaining witness stated she decided to sever a relationship with her daughter and informed the defendant that she would be moving back to Arizona. The complaining witness stated this upset the defendant and he began arguing with her. She then expressed that she hated him and this made the defendant more upset and he told her to hit him if she hated him so much. The complaining witness stated she hit Mr. Sullivan with a closed fist on the head and face area 3 times before losing balance, slipping and falling. This fall caused her to hit her face on their bedroom dresser. The complainant then said she got up and crawled into bed, and she was laying on the furthest corner of the bed closest to the wall and covered her body with a blanket. The complainant witness stated that approximately 10 minutes went by. Mr. Sullivan, the defendant, continued to argue with her. He crawled on bed, grabbed her, flipped her over, her back was on the mattress, and used his body weight and then on top of her while placing both hands on her upper arms to hold her down. The complainant said this caused her pain, and she was able to free one of her arms and use her hand to grab the defendant's genital area and making him let go of her completely. The defendant then used his right hand and punched the complaining witness on her mouth, causing pain and visible injury. The complaining witness added the fight then diminished, is that the law enforcement officer observed visible injuries, including large purple bruises on both arms and injuries to the top and bottom inner glove.
Laser, you hearing this?
Yes, Your Honor.
Interesting. So she's the initial aggressor, though, correct?
Your Honor.
So it looks like he says, hey, hit me, antagonizing. She gets into it. She pops him, what, 3 times in the mouth, you say?
Yes, Your Honor.
Don't say anything. Sorry.
So, Your Honor, only thing I would ask is, this is not home court's case. If we can just stand down, wait for the DVD prosecutor to be here. I don't know if he's spoken with the complainant yet, if he has anything more to add. I would just ask the court to withhold the finding until we can get the prosecutor.
All right, Mr. Sullivan, just do me a favor. Will you just take a seat behind the jury box? I'm going to get Yeah, I'm gonna also appoint him a lawyer, if you don't mind. I'm gonna appoint him someone as well, so we can do just.
That's totally fine, Your
you know.
Honor. Let me, and I'll email DVDs.
Okay, all right.
Thank
Do me a
you.
favor, just take a seat for me real quick, all right?
All right, Judge, next is.
You're Abner Guzman.
Guzmán.
Sí.
Yes.
Mr. Guzman, you're
Señor
charged with
Guzmán,
displaying a
acusado
fictitious license plate.
Con red placas.
6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed for you, sir.
Thank you. On March 24th, 2025, at around 11:20 a.m., officers were dispatched to a B&B call at 2520 Airline Drive in Harris County, Texas. Upon arrival, officers observed the defendant's vehicle parked in the west side parking lot near the fence of the
Houston Farmers Market.
with the front passenger window
Con
broken.
la ventanilla del pasajero del frente quebrada.
Officers conducted a
Los
vehicle
oficiales
check
hicieron un registro de vehículo
on the temp license
en
plate
la licencia de manejar temporal.
and returned did
Pero
not
la
match
placa y regresó, lo tenía ahí.
the defendant's vehicle.
Del acusado, el vehículo del acusado.
At 12
A
p.m.,
las 12 p.m.
the defendant arrived
el
on
acusado
scene,
llegó.
told officers that he was the owner of the
Le dijo al oficial que
vehicle.
era el dueño del vehículo.
Defendant was
El
detained.
acusado fue detenido.
Defendant said he had purchased the
Luego
vehicle
compró el vehículo
5 years prior
5 años anterior
in Florida
en la Florida.
and paid an additional fee for the seller
Costas adicionales al vendedor
to change the title
para que
to
le
his name.
cambiara el título,
But the seller did not do that.
pero el vendedor no lo hizo.
Defendant stated he met a
El
woman
acusado declaró que él conoció a una mujer
on WhatsApp
en WhatsApp
who offered him a
que
fake
le
temporary license
ofreció
plate
una placa falsa temporal
for $40,
por $40
which he purchased.
que él compró.
Defendant stated he had
El
been
acusado
driving the
dijo que había
vehicle
estado manejando el vehículo
with fake temporary
con
license
las
plate
placas temporales falsas
for 4 years.
por 4 años.
The defendant was
El
ID'd by his
acusado fue
Guatemalan.
identificado por el pasaporte de Guatemala.
Mr. Guzman, I'm going to find that there's sufficient probable cause to go
Suficiente causa para seguir
forward.
hacia adelante con su caso.
If you do not have a Texas
Si
driver
usted no tiene
license
licencia de
and
manejar de
liability
Texas,
insurance in your name,
seguro,
you are not allowed
su
to
nombre
drive.
no se le
I
permite
don't
manejar.
care what you need
A
to
mí
do in
no
this
me
life.
importa qué tienes que
If
hacer
you're not
con
properly
esto. Si
licensed
usted no tiene
and have
licencia
insurance,
funcional y tiene seguro de carro,
not
no
drive.
maneje.
You'll be signing a promise with me. This is an affidavit that you're going to swear to me that you're not going to drive.
Usted no va a
You cannot justify driving for any reason.
manejar
If I find that you do, I will revoke your bond and put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail,
a la cárcel,
and immigration finds you, they will put a detainer on you and you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand?
entiende.
Sí, sí.
Yes.
Do not
No
drive.
maneje.
This is the only bond condition that you have. Do not pick up any new cases as well. If I find that you're a danger to my community, likewise, I will put you in jail.
Igualmente no.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him. If he tells me that he cannot get a hold of you because you're playing games, you're not responding to phone calls, text messages, likewise, I will revoke your bond. Do you understand?
Lo entiende. Yes.
Okay. I'll have you sign a receipt of Victoria. We'll have you swear to us that you're not going to drive, and after that, you're free to go.
Thank you, Judge. Maybe excuse me. Thank you.
Yeah, take care. Hey,
Aaron Durden, bond violation report. You said bring him today. He's here.
come up, Mr. Durden. We're here on yet another bond violation report. It is now alleged that the client was instructed to install an ignition interlock device, not to tamper with the device, to blow into it. And from 2/20 to 3/20/25, you skipped 8 tests, not using the device as instructed.
I'll explain, Judge.
Please.
All those violations except one are on the same day.
If you look at the photos, there's only one person in any of the photos. It's not him. He owns a company. He allowed his employees to drive the truck. They didn't understand the deal. All the other pictures show nobody in the truck. What they did, the roofers, they just left the truck running while they were doing work to keep the climate control on. He has since clarified that. We've emailed pretrial last week asking them to try to get the photos before the violation so we could see who was actually driving the truck, but we didn't hear any response.
He has guys, does he have a blow schedule that he's supposed to blow? He has a blow schedule. He's supposed to blow at certain times and he's not blowing.
Are you not blowing at certain times?
That's not, no, that's not true, Your Honor.
I have here 8 skip tests.
No. So one of my guys was driving the truck, and he did not. I didn't instruct him that when you stop the vehicle, that you can't just leave it running. So he wasn't informed about that. So he just left the truck.
But it was rolling retests that were skipped. That's the allegation. Rolling retests. So somebody started the truck, got out of the truck, and left it running. And it just kept saying blow, blow, blow. If you look at the times and date, they're like 5 minutes apart for 15 or 20 minutes.
Yes, Judge, I do see that it's the rolling retest. As far as what specifically that entails, honestly, that's something I haven't encountered before.
I haven't either, but bottom line, he's supposed to test at certain times.
Yes, but that would be a missing test, but the allegation is in the bond violation, rolling retest.
So yes, there's no allegation that he has missed his flow schedule.
What times do you have this time set that he's supposed to actually blow?
I can reach out to the manager and provide information.
Do you mind? I'd like to know what specific times is he supposed to test? And did he actually do it on that times, or is it someone else blowing? That's what I'd like. So let me see what they say and then we'll come back.
Judge, I have Marina Odiambo on today's docket. He's doing the DWI PTI program. He just needs a little more time to get the device.
Last name is
Marina Odiambo. It's hyphenated. She's been having some financial issues, and so he's trying to get some money together to get the alcohol monitoring device. And we also need to submit the industry affidavit, but he's provided that to me to get the
213 days old.
Just we can get 2 weeks just for him to get the device. That's all we need. We have the contract already, and we just need to get the fee waived as well.
Bring him up.
Yes, Judge. I'm just trying to get this wrapped up, Judge, and we're really close.
So are you doing that for the fee, right, James?
Yes, Judge. We have to submit the device, or we have to submit the industry affidavit for the $300 fee, and then he also has to get the alcohol monitoring device.
Filled out the affidavit.
Judge, he has that filled out. It's just I need to get a PDF copy of it, and he says he can scan that to me.
You have everything now because we can scan it, bring him back, and I can.
No, Judge, he took photos of it, and that's not going to work for them.
Your case is 215 days old. I'm not giving you any more time. It's not, if you don't have it done, I'm going to immediately set you for trial, or you're going to take a plea bargain agreement from the state. But I'm not giving you any more time after that. You need to have everything done by that time. You need to submit the affidavit today, not tomorrow, not next week, because they need time to review it to see if they're going to grant it for you. I will not give you any more time after this 2 weeks. If you don't have it done, I will bring you back day for day until you have it done. Do you understand? Okay.
Thank you, Judge.
That's
Can I get
final
2
2
weeks? Thank you, Judge.
I just got hired on Miss McKelvey. This is the one you emailed me about. She's in the box. Pretrial has indicated to me that she did take a test last Tuesday and she did test negative. She tried to go to Quest, which we sent her to. They wouldn't take it because they didn't have enough information. But she ended up testing, I guess, through pretrial.
Yes.
Okay.
When did you test last?
Tuesday.
Tuesday, just the 25th of March.
Okay. Come on, Mr. McKelvey. I'll just admonish her now.
Thanks, Judge. I told her zero tolerance. I mean, she's a real sweet lady. I don't think you're going to have any issues with her in the future.
It's no tolerance. If you miss again, it's not going to go well. All I'm asking you to do is show up when they call you to take a test. You understand?
Yes, sir.
So right now, nothing's going to happen today. But if it happens again where you miss a test, then I will issue a warrant. No tolerance. You understand?
Yes,
You're
sir.
not to use any alcohol, you're not to use illegal drugs, and that's how we ensure that it doesn't happen. Understand?
Yes, sir.
Okay, all right, all right.
May she sit in the audience? Thank you.
Good morning, Your Honor.
How are you?
I'm fine. I don't have any big problems today.
Something nice.
All I need is a reset for 45 days. The prosecution and I have come to an agreement. Christian Willis. The prosecution and I have come to an agreement as to the resolution of this case. He just needs about 30 days in order to.
It's nearly 200 days now. What do you, what did they offer? What did they offer?
We've offered a PTI now, Your Honor.
And what did,
So I spoke to the weapon and gun safety class and a drug and alcohol awareness class, I believe. And a drug awareness class, I believe.
so I'm gonna give him 2 weeks to get the stuff done.
2 weeks?
Yeah, it shouldn't take that long. It's a gun safety class, it's probably 2 hours.
Yes.
And the other class also is just a couple hours.
So
So
can we do 3 weeks instead of 2? Because I still have balance. 3 weeks. 3 weeks. Thank you, sir.
Mr. Willis, where's Mr. Willis?
He's out here.
Come up.
This is the first time ever getting in a.
Mr. Willis, he has secured you an amazing deal where if you do 2 simple classes, both of your cases will get dismissed. If you do not have if you don't have them done in 3 weeks, I'm not going to take anything else. I will immediately set your case for trial. Do you understand? There's no excuse why you can't get both classes done in 3 weeks. All right, Mr. Cashin.
Thank you, sir.
See you.
See you next time.
Take care. Hey,
Judge, we're here on Mr. Aziz. Newly retained on the case, Judge. Newly retained on the case.
oh, you retained?
Yes.
Got it. Okay, so come on up. We were waiting because he said that he hired a lawyer. We were waiting to see him. Come on up, Judge. So have we done PC on this case yet?
Judge, he was CHA. They just had to sign on.
Okay, so we have here, do you mind doing me a favor? Can you run his license to see if he has a license? Sure. This is a failure to stop and give him information.
Yes, sir.
Leaving the scene of an accident. So I just want to make sure that if you're going to drive, that you have a valid Texas driver license and liability insurance. If you do, then you may continue to drive. If you don't, then I'm making it a bond condition that you not drive until you have both of those things.
Yes, Judge.
Yeah, this is where Defendant is eligible.
Okay, you do not have a Texas driver license.
I have a California driver's license. I was stationed in California. I'm a veteran.
Is it eligible?
It does say eligible, Your Honor.
Okay. All right, so one of your other bond conditions is you are not allowed to drive unless you have liability insurance in your name. That is a bond condition. Find that you drive without car insurance, because all I'm asking you to do is follow the law. If I find that you don't, then I'm going to put you in jail. You understand? Great. You've got a lawyer. Because you have a lawyer, we will waive your appearance. So you don't have to waste your time coming to court, but you must stay in touch with them. They'll tell you if and when you have to come back to court.
Quick question.
So,
Do I just need to come back with like my insurance and give it to them so that they know that it's valid?
yeah, just let them know, then they can show it to us so that we can verify it and then you're good to go. But like I said, I'm waiving your appearance. You don't have to waste your time coming to court, but just stay in touch with them and they'll tell you. If they tell me they can't get a hold of you because you're gone, then I will issue a warrant for arrest.
Okay, sure.
You don't pick up any new cases. Got it?
Judge.
We're good.
Thank you.
Thanks, Judge.
So don't leave until you sign the conditions and then after that, you're free to go.
Yes.
So he filed no driving without a valid license and liability insurance.
Yes, Your Honor.
Okay. Thank you. Guys, have fun.
Urging on Jasmine Tovar Martinez, Judge. She had a BVR. On Friday, she came to court. She was sent to go get drug tested and it's negative. She is present. Martinez had a cause of mercy like that. That's it. That's the one.
Judge, it's 254.
8319.
I think just.
First.
Ms. Tovar, come up. Did we put a scram on her?
I believe that's what happened. I wasn't here on Friday. We should do this.
Do you mind checking?
Yes, Graham device that Friday.
That's positive again. It's not gonna go well for you. You better know every single thing that you put in your body before you do. If I see that you have a positive and you try to tell me it's mouthwash, it's a tequila lollipop, it's hair dye, I don't care. No more excuses. You understand? Okay? All right.
Thank you, Judge.
Thanks, man. Yes, sir.
Okay, have a seat. Give me 1 second.
Who's the guy that took in? Mark to you.
Oh, James.
Almost all the letters? No, I don't need it. Yeah.
So 30,006.
30,000?
And six. No, maybe I'll make it higher.
What do you think? No, they didn't say it's Slim's fault. I let them know. Okay. Did you do that? Yes. State need. Bond.